All right. Hi, everybody. We are here today with Shelly Schools, who has joined Contigo Law's of Counsel. Shelly, can you tell us a little bit about your experience before we start talking about some other issues?
Hi, Gage. Good morning, and thanks for talking to me. Yes, so I've been practicing law for 28 years. I started out in the Air Force. I served on active duty for 22 years in a variety of positions, focused mostly on criminal law, including prosecution, defense, appellate defense, and then I was a military judge for 4 years. I spent the last 6 years, though, as an immigration judge in Fort Worth, Texas, where I presided over or more than 4,000 hearings of all kinds of types, bond hearings, applications for relief, including asylum, cancellation of removal, and adjustment of status. I resigned that position effective September 30th, 2025. So I'm no longer an immigration judge, but I did serve there for 6 years.
Excellent. We're sure excited to have you on board. Even just yesterday, we had a complicated case come up, and you're like, "Oh yeah, I approved a couple of these on the bench," and your experience is very valuable. So we really appreciate having you on board. So we wanted to introduce everybody a little bit to Shelly, and we have some questions we're going to ask her that hopefully you will find valuable. Having her perspective on board is incredibly valuable. And how often do you get to hear from a former immigration judge on what it's like to be in that setting? So the first question, Shelly, is what is the single most common mistake you saw pro se or self-represented clients make in the courtroom?
The single most common and probably the biggest mistake pro se individuals make is not providing evidence to support their application. When you fill out an application, whether it's for asylum, cancellation of removal, or something else, you have to prove to the judge that what you wrote in that application is true. The judge should, during the immigration court process, instruct you on the requirement to provide evidence. And some judges, I did this, would give examples of the kind of evidence that you should provide. For an asylum case, I would tell people you should provide witness statements, medical reports, police reports, photographs of your injuries. If you do not provide evidence to prove to the judge that what you've said in your application is true, the judge can deny your application, even if what you've said is in fact true. It's not enough to say it, you have to prove it.
That's an excellent point. We've had so many cases where even proving it, the judge will say, "I believe everything you said, but the law says XYZ," right? And it can be a very difficult thing. But when you're talking about proving your case, when there's competing testimonies or evidence that's complicated, the government is submitting evidence that says something contrary to what you've submitted. How would a judge go about deciding which set of evidence to use in their decision?
So the general rule is the judge is trying to determine if the witnesses, including you as a respondent, and the evidence is credible. And what we mean by credible is believable. The judge makes this decision based on a variety of things. For example, if a witness is testifying and they start to change their story, or if the witness is testifying and the story they're telling is different from another witness or other pieces of evidence, or if the judge asks the witness a question and they won't give a straightforward answer. All of these things are indications to the judge that maybe the witness is not telling the truth. And the same is true for documents. The judge wants to know that this document is real and that what it says is true. For example, if you provide a birth certificate to prove your identity, but that document has a lot of misspellings or doesn't look like it's from an actual government office, the judge might find that that document's not real. And if you provide documents that the judge thinks are not real, then the judge is not likely going to believe what you tell them either. For example, or here's another example, if you provide a medical report about injuries that you suffered and you told the judge that you had a broken arm, but the medical report says you had a broken leg, the judge has to decide, is this medical report not real or did you not tell the truth? The judge considers all the testimony and all the documents, looking for those kind of indicators. Is it consistent? Is it believable? Does it look like what it's supposed to look like?
Yeah, and that can be a challenge when you're submitting several hundred pages. And so it would be smart for somebody that's doing this pro se, of course, to know all the dates and check for those consistencies, right? Because one date on this affidavit, if it doesn't match this police report, can throw all of it into disarray.
Absolutely. And when you talk about a complicated case or a case that involves lots of different things that happened, the judge doesn't expect one person to perfectly memorize every date and every single detail, but there should be a general consistency in the evidence, whether it's testimony or documents.
Yeah. Okay. Great. Thank you. That's super helpful to hear your perspective. What are your top 3 recommendations for a client preparing to testify in their individual hearing? An individual hearing, for those that may not know, that's your final hearing where they decide your application. So what are the top 3 things for people who are going to be testifying in an individual hearing?
Well, I'm going to give you 4. And the very first one gets back to what you just mentioned about, understanding or remembering dates. The first thing you should do is review all of your prior written statements. Some people think this is wrong. Oh, if I review it, it's going to look like I tried to memorize it. No, we're human. We're not perfect, and we forget things, even important things sometimes. Review your application. Review any written statement you've made. If there's a transcript of an interview you gave with a government agent, like a credible fear interview, you should review it. Not to memorize it, but to refresh your own memory about the important things that happened that are relevant to your case. The second thing you should do is, if you don't know the answer to a question, or you don't remember the answer, say, I don't know, or I don't remember. Some people think they're not allowed to say that, or if they say it, it'll make it look like they're lying. But it's far better to say you don't know or you don't remember than to make up an answer that might end up being inconsistent with other testimony and documents. And now it looks like you're not telling the truth. It's okay to say, I don't know, or I don't remember. Third, if you don't understand a question that's being asked, it's okay to say, I don't understand. If you have confusion about the question, but you try to answer it anyway, it might look like you're not answering the question that's being asked. And when people avoid answering questions, again, it looks like you're not being truthful. It's okay to say, I don't understand the question. Can you ask it again, or can you ask it differently? And then my 4th piece of advice is never talk over the lawyers or the judge. If they are speaking, then you need to sit quietly. This can be frustrating because sometimes you feel like you're not being allowed to talk, or you're not being allowed to tell your story. But it's worse if you are being disrespectful by talking over the lawyers, and the judge would probably reprimand you or caution you against doing that. What you should do instead is wait for your opportunity to speak and then say to the judge, there's more I would like to say about this. May I speak now? And hopefully the judge will give you that opportunity.
Yeah. Those are excellent points. Those are excellent points. I do have one question for you. What would you tell somebody testifying in court when they say they don't know or they don't remember, and then they're followed up with many pressuring questions from the government attorney? Because I've seen that happen quite a bit, and then people start to feel nervous, and then they start to make mistakes. What would you tell somebody in that situation?
Yeah, so as soon as someone says, I don't know, and it's about an issue that seems important to the case, then a lot of times the government lawyer will attack, and they will jump on that and like you said, start making the situation more uncomfortable. What you can simply say is, I'm nervous, I'm anxious, and I just don't remember. If I could look at my application, or if I could look at the declaration I wrote, then I'd be able to tell you. But I don't have it in front of me and I just don't remember. Don't let the government attorney bully you into giving an answer if you don't remember it. Just keep saying, I'm sorry, I don't remember, or I don't know.
Yeah, that's great advice. Okay, so the next question, how much does a client's demeanor or personal presentation in court actually influence the judge's decision?
And I assume you mean by personal presentation, you mean like the way a person presents themselves in court?
Well, let me give you one example.
Okay.
I had a client years and years and years ago, and without giving any identifiable information, wore a piece of clothing that had a very inappropriate term printed on it, and obviously that didn't go well. And so I've had that in my mind often when I'm advising clients prior to a hearing on how they should dress or how they should prepare themselves. But their demeanor and their personal presentation, maybe it shouldn't influence the way that a judge decides a case. But what would you say to somebody regarding how it would or how it could?
Well, I do think it matters. And let me give you some pointers on things you should do when it comes to your demeanor and how you look and act in court. First, always be on time. Second, dress appropriately. You're going to court, not out to dinner, not to the bar, not to a party. The judge is not going to expect you to show up in a suit like maybe the attorneys show up in or should show up in, but you should look nice. Clean clothes, not clothes with rips and tears, not clothes with advertisements and words on them. Now, and another thing you should do is always look the lawyers and the judge in the eye when you're speaking to them. Why does this matter? It communicates to the judge that you understand the seriousness of what's happening. The immigration court process is serious. It impacts your life in a very real way. And it communicates to the judge that you understand that. It also communicates to the judge that you respect the court and the process. Now, should it make the difference in whether a judge grants or denies? No. If you have a case that meets all the legal requirements for relief, then the judge should grant that application. But most applications that appear in front of a judge are discretionary, which means the judge can decide, even if you meet all the requirements, the judge has to decide whether you deserve to have this relief granted. Don't give the judge a reason to say that you don't deserve it. I think it would be pretty petty for a judge to deny a good application just because they don't like the way a person has dressed for court. But better be safe than sorry. Dress professionally, behave appropriately, look the lawyer and the judges in the eye.
That's excellent advice. One thing that I tell clients going into court is, dress professionally, like you said, but also dress so that people aren't going to remember what you were wearing. You don't want to have a visual lasting impression when the judge is typing something down, like, oh yeah, this is the guy with the marijuana leaf on the shirt. I mean, that's an extreme example, but
but a very realistic one. Yeah. Don't be a story that someone tells later about how someone looked or acted in court.
Yeah. Okay. Excellent points. Thank you. And it's great to hear it from your perspective. A lot of clients, a lot of respondents, respondents are, for those that don't know, in immigration court, in criminal court, people are called a defendant. In immigration court, they're called a respondent. So a respondent, who's trying to hire a lawyer, obviously there's a lot of lawyers out there and it's very difficult. And I'm not trying to necessarily put a plug in for Contigo Law. I'm asking, from your perspective, what are things that lawyers can do during the hearing that are most effective? What should clients be looking for in the representation from their lawyer?
So in my opinion, it's not so much about what you're doing in court, but what you've done before court. The most important thing a lawyer can do for their client is to be prepared, because a prepared lawyer will be effective in the courtroom. A prepared lawyer is going to be ready for the unexpected. The judge saying, oh, we don't have 4 hours for this hearing, you get 2 hours. And now you have to, at the last minute, figure out how you're going to present your case within that time constraint. If you're prepared for your case, then you can make those kind of changes on the fly. So being prepared, the lawyer being prepared, is the way to be effective in court. The best lawyer is still going to lose a case if the facts simply don't meet the legal requirements for relief, but an unprepared lawyer can lose a winning case. Now, as a respondent, it's your job to give the lawyer the information they need to be prepared. So it's not just the lawyer's responsibility. They need your help working closely with them, giving them all the information so they can research the right issues, and then they walk into court unprepared. You've got to work as a team ahead of time. But I can almost guarantee you that if your attorney has done the preparation that's required, they're going to be effective in court. That doesn't mean they're going to necessarily win, but they will give you their best representation if they walk in prepared.
That's excellent advice. It's so difficult when clients won't give us the documentation that we've requested prior to the hearing, so that we can't do our preparation beforehand. So yeah, thank you for that. Really, the best preparation is the best way to show up to court. And how many hearings have we had, especially recently, where we walk into court and it seems like the decision's already been made, right? There might be a few issues here and there, but decisions are made more and more off of the record, the paper that's been submitted ahead of time.
Well, I can share with you how I would do it. I walked into individual hearings 90% sure of the outcome. I have pretty much always already decided, because I have done my job as a judge to prepare based on what the lawyers have filed. I should have already been able to identify where the sticking points are, where are the issues that are in dispute. And we are in that individual hearing going to focus just on those issues in dispute, because I suspect I already know the outcome. This gets back to the issue of preparation. If the lawyer is prepared and has already filed the evidence that the respondent or the client has given them, they've been able to research the issues, they've submitted their brief. I already know your argument. I already know the facts of your case. So now we're just going to resolve the probably few unresolved issues. So I think it's very reasonable to say that most judges go into the hearing already knowing what the outcome will probably be.
Yeah, that's and that's what we've been seeing, but it's so helpful to hear it from your perspective. That yeah, you've got to submit your evidence, you've got to get it in, and the judge is going to review it with a fine-tooth comb, like you always did when you were on the bench. Okay.
Yes.
All right, next question. If I have an old criminal issue, even a minor one, how should we approach discussing it with the judge?
Always be upfront and honest about any criminal history, no matter how old or how minor you think it is. And if you have an attorney, so I'm speaking to respondents out there, if you have an attorney, you need to be honest with your attorney too, because I have seen many occasions where the government presents evidence of criminal history that the lawyer for the respondent knew nothing about. If you have a documented criminal record, I guarantee you the Department of Homeland Security lawyer already knows about it, and they're going to tell the judge. You should be the first one to tell the judge. And if the judge asks you questions about it, don't try to minimize it. Don't try to make excuses for it. Say what you did. Tell the truth. Give an expression of remorse. And then you just need to convince the judge that you learned your lesson. There haven't been any repeats, and there will not be any repeats in the future. But the moment I see someone minimizing, making excuses for their conduct, it tells me they don't understand the seriousness of their behavior. And if it is a discretionary type of application, that weighs heavily against you.
Yeah, you don't want to be caught hiding anything.
That's right.
Okay, great. And also on that vein, it's really important to try to, there are certain criminal convictions that are going to require a mandatory denial. So it's really important to consult with a lawyer ahead of time so that okay, this thing is in the judge's discretion to decide for or against you, or this thing means they have to deny your application.
That's a good point. I mean, if you're not being honest with your attorney about your criminal history, they can't properly advise you on the strength or weaknesses of your case. And there are some convictions that simply just make you not eligible, and the judge has to deny whether they want to grant or not. But if you haven't told your lawyer that, you've wasted your time, you've wasted the attorney's time, you've wasted your money. So be honest and upfront with your attorney, and they can figure out the best way to put it before the judge.
Yeah, thank you. Thank you. Okay, the next question. What kind of evidence beyond just personal testimony did you find most compelling and persuasive?
Well, any evidence that actually proves that what you've said is true. So in the legal world, we call this corroboration. So the judge is looking for corroboration. For example, if you testify that a police officer in your home country beat you with a baton and broke your arm, you should have proof of that. Almost everyone nowadays, and pretty much every country around the world, has a telephone, right? And we take pictures of everything. So you should be able to provide a judge a picture. If it's a broken bone, you probably got medical treatment. Most people do for a broken bone. So where is that medical record? Maybe a friend or a family member was with you when you were beaten. Or if not with you, then they saw you afterwards, after you came home from the hospital with your arm in a cast. They should write a statement about what they saw and maybe what you told them at that time. When your testimony doesn't match the documents, or when you don't give documents at all just because you think your testimony is compelling, chances are you're going to lose your case. What is compelling to the judge is that you've told a story and that you have evidence that says that the story that you've told is true. It's just difficult to believe in this modern era that people don't have access to some type of evidence to prove their claim.
And can you give us any insights on what would happen if a respondent showed up in their asylum hearing and their statement says they attended protests, those were on social media, they filed a police report, etc., and they don't submit that police report or pictures that would have been taken or something like that?
So most of my cases were in the Fifth Circuit. And just to explain what that means to folks is that every immigration court falls within the jurisdiction of some federal circuit, some federal court system. And those federal courts decide how to interpret immigration law. So in the Fifth Circuit, the court has said that even if someone's story is believable, and even if it's in fact true, if you could have provided evidence and you failed to do so, that is reason alone for the judge to deny your application. I have said to numerous people, your story is compelling. And if what you've said is true, you might be eligible for relief. But you have not convinced me that you could not provide evidence to prove that what you've said is true. And because that is the requirement, that you provide evidence and it was available to you, you just didn't, I'm denying your application. How
Wow.
important is that? You are eligible. What happened to you satisfies the legal requirements, but you just didn't bother to provide the evidence to the judge. Now, do you have to provide 10 witness statements and hundreds of photographs? No. But you should be able to provide meaningful evidence, some evidence that what you've said is true.
Yeah. Excellent. And so important, especially as it's becoming more and more difficult to get an application approved in court. You have to back it up. Okay. The next question.
Well, actually, let me add to that, though. Now, with a lot of judges doing something called pre-termission, where they're not even giving you a chance to have a hearing because what you filed is not enough by itself, sometimes you're not even going to get a chance to explain yourself to the judge. That is why it's important that you file an application that is thorough, that's complete, that tells your full story, and attach the evidence or file it within the deadline set by the judge. Because if the judge is making a decision just based on your documents and you haven't provided anything, you lose before you ever come to court.
Wow. And yeah, we haven't been seeing a lot of that in Utah yet, but it's probably coming. And
I agree.
we've got to start preparing cases accordingly. All right. If my case is denied, what is the most important thing I need to understand about the next steps or the appeal process, including some of the new regulations that have been proposed coming up?
Well, the first thing you need to do is understand the deadline. You get 30 days from when the judge decides your case to file an appeal. If you wait until day 31, that is reason alone for the appellate court to not even take your case, which means they're not going to review anything about your story. They're not going to review anything that the judge did or did not do in your case. So if you file an appeal, it must be on time. Second, don't expect that process to go quickly. When I was a judge just as recently as last year, for people in detention, the appeal process usually took anywhere between 4 to 6 months. And for people not in detention, it could take years. There are hundreds of thousands, maybe millions of immigration cases out there. I'm never sure what numbers are true or not, but people not in detention typically reserve appeal because why not? There's nothing that hurts you to reserve appeal. It buys you time, if nothing else. And so there are a lot of cases pending on appeal. That's why it can take a long time. So you have to be patient. Now, you mentioned these new regulations. I'm not sure how that's going to play out. This idea that the immigration or the appellate court will automatically dismiss appeals unless there's some agreement to review it is very odd to me. It's just not the way appellate courts typically operate. If this process changes, though, then everything I've said might be irrelevant. You'll still have the 30-day deadline for appeal, but decisions might be made really, really quickly and unlikely in your favor. So you have to decide if it's worth it to you to wait around for the process or to just take the order. But if you are going to appeal, you've got to meet that 30-day deadline.
Yeah, thank you. And the new regulations may change a lot of appeal deadlines to 10 days and like you were saying, not allow for significant review. It just might decide the appeal on what's filed with the initial appeal. And versus right now, you file your notice of appeal within 30 days. They're going to type out every single thing that was said in court, give that to the attorneys so they can adequately brief it. I've had some appeal cases that are taking 6 years to get through it. And obviously the government has a need to cut down that adjudication time, but we'll see what comes of these new proposed regulations. I know a lot of us are worried.
Well, I mean, it's just not the way it's described is not meaningful appeal. I think part of the issue with immigration court is, it used to be many, many years ago, a purely administrative process and maybe almost exclusively a paper process, but we've created a system that looks and feels like a regular court system, including an appeal process that looks and feels like a regular appellate process. And now it almost seems like we're retracting that. We're going back to something that's less formal. And I'm not sure that will stand up. We'll see.
Yeah, we'll see. It's an interesting time to be a lawyer. Okay. What advice would you give to someone who is nervous or scared about appearing in front of an immigration judge?
Most people are nervous and scared, and that's completely understandable. Judges recognize that, and I would like to believe that judges are empathetic and understand that people in front of them are nervous and scared. It's okay to tell the judge, I'm really nervous. Sometimes we can tell by someone's demeanor or the way their voice shakes. That's okay. You can tell the judge, I'm really nervous or I'm scared. We understand that this is a significant event in your life, whether it's your first hearing or your final hearing. This entire process is a significant event in your life, impacts you, usually impacts family members. So that's okay. What I would tell you, though, is regardless of being anxious or scared, answer truthfully and look the lawyers and judge in the eye when you're answering questions.
I like to tell people, like, look, if you're not scared, there's something wrong. Because this, for a lot of people, this is one of the pivotal moments, or one of the most important moments in their life, whether they're able to adequately present their case or not. And
Absolutely.
it's good to hear you say that judges understand that, because I've had clients that get so nervous on the stand that they forget their first name. That's happened. And I can't blame them for that, because of what they've been through and how meaningful this hearing is for them. So I always tell people, look, to be nervous is normal. What we need to do is use it in a productive way. We need
Yes.
to make that nervousness help us to better prepare ahead of time.
Absolutely, because just like being prepared makes for an effective lawyer, being prepared will help the client or the respondent feel more comfortable about what's going to happen in court. I've seen people so nervous, particularly they struggle with remembering the dates of birth of their children. We celebrate birthdays in this country, but not every country attaches significance to that. And I've seen plenty of mothers and fathers like, oh, I cannot remember when
Yeah.
my son was born. I'm just too nervous. Understood. It's not a big deal.
Yeah. Yeah, that's a common one. Or what day were you married? I've seen a lot where I won 30 interviews.
Yes.
Okay. What should a respondent do if they are having difficulty understanding the interpreter?
What a great question. Let's first talk about how important the interpreter is in this process. A competent and reliable interpreter ensures that everything is being translated correctly and completely. In fact, the interpreter has to take an oath to do just that. Misunderstandings between you and the interpreter can be the difference in a claim being granted or denied, because if the information that you are providing is not being completely and correctly translated to the judge, then the judge might not be getting the information they need. So the interpreter is critical. So if you cannot understand the interpreter, you must tell the judge right away. You can say, Judge, I cannot understand the interpreter. If you have a lawyer, tell your lawyer right away, I'm not understanding the interpreter, and they will let the judge know. One of the most common ways I've seen this come up is with dialects. The interpreter is from the same country as respondent, but a different region. And dialects matter in our everyday speech and the meanings of our words and phrases. So it's important to say. Now, usually an interpreter is ordered for every hearing. So if you're having problems with this interpreter, the judge might have to delay your case. That's frustrating for everyone, but this is too important for you to go forward, especially with a final hearing, if you don't understand the interpreter. Tell your attorney or tell the judge right away.
And what would, if the interpreter just isn't able to interpret adequately, what is typically going to happen in court? What would a judge normally do?
Well, if the judge believes that the interpreter is simply not competent, for example, if the respondent is giving an answer that's several sentences long, I can tell that it's a long answer, and the interpreter gives me 4 words in response. That's not right. I know the interpreter is missing something. If a judge thinks the interpreter is not doing their job correctly, they can actually report that interpreter. That's a separate process that happens outside of the court process and has nothing to do with the lawyers or the respondents. But that's something a judge actually is responsible for doing if they think the interpreter is not competent for the job. But what the judge is going to do in real time is ask you to be specific about what problem you're having. Maybe give an example of what the problem is. And if it's obvious that this is not going to work, the judge may do one of 2 things. Try to find an interpreter so we don't delay the case. If it's a commonly available language like Spanish, then the judge can probably find a Spanish interpreter pretty quickly with just a short break and then continue the case. But if it's a significant issue or a unique language, your case is probably going to be delayed. And then what the judge will do is let the court staff know that we need to order a specific interpreter from a specific region with a specific dialect. I many times ask the respondent, tell me exactly what you need, what language, what dialect, what region. The more specifics you can provide, the better interpreter the court can try to get for your next case.
That sounds very complicated in some of those smaller regions of of
Yeah,
obscure languages, but it's incredibly important.
yeah.
I've had lots of cases where, one or two words, the case can hinge on one or two words, and if the interpretation is wrong, you're going to get a different outcome than anticipated.
Just think of the difference between the answer yes and no. You would think it's not possible for that to be misinterpreted, but if it were, that's important.
Yeah, I can't imagine messing up the interpretation that bad, but I'm sure it's happened and you've seen it.
Well, some of our judges actually speak other languages, and if they've got an interpreter of a language they speak, some of them are more in tune to whether the interpreter is doing a good job or not a good job.
Yeah.
I'm not bilingual. I relied on my interpreter, but there are some times when there are red flags, or I can tell something's not quite right.
Yeah.
Hesitation on the part of the respondent, and then I inquire. Is there a problem with our communication? Do you understand what the interpreter is saying? What difficulty are you having? It's the judge's responsibility to make sure that the respondent's able to communicate clearly with the court. The judge should be in tune to that, but you should also say it if you're having a problem.
Yeah. Interesting. Okay. And that's one of the areas where I've had to make the most objections, as I speak Spanish, right? And there's almost never a hearing that goes by when I don't have to object, and I feel bad doing it because I don't want the interpreter, who's trying really hard. They're usually very well intentioned, but you have to get it right. You just have to.
That's right.
Okay. Is a respondent allowed to ask the judge for more time to prepare for their case? And do judges usually grant those requests? That's a big topic.
You're allowed to ask the judge for anything, but let's talk about the likelihood of it being granted.
Yeah.
Particularly if you're pro se, meaning you do not have a lawyer, you will have several immigration hearings before your final one. And at some point during that process, the judge should tell you, you have a deadline to submit your evidence, and the judge should give you a date. You have to file your evidence by a certain date. If the judge gives you a date, make sure you write that date down. If you're coming up on that date and you have not filed your evidence, or you haven't filed all of it because you're waiting on something, you can write a letter to the court and say, Judge, may I have more time? But be specific. I rarely granted continuances for someone who just said, well, I'm still trying to collect evidence. My questions are, what evidence? From whom? When do you expect to get it? So if you need time, be prepared to answer those questions. And I would recommend you do it ahead of time. A letter to the court. Here's what I'm waiting on. Here's when I expect to get it. And then the judge is more inclined to grant a continuance, which means, and the judge is applying a standard called good cause. The judge is more inclined to give you a continuance if you've asked ahead of time before your deadline has passed. If you show up for your final hearing and say, Judge, I don't have all my evidence, I need more time, the judge is going to say, why did you wait until today to tell me? I told you at our last hearing, your deadline was X date. It tells the judge that this is not important to you, and you should not expect the judge to grant a continuance if you waited until your final hearing to ask for more time. Have I granted such continuances? Sure. I've had people give me a compelling explanation about why they didn't get their evidence and why they didn't ask beforehand, and why this evidence is so important to the case. It can make the difference between granting or denying. But don't expect the judge to be generous with their time, because here's what you've done. If you show up for the day of your hearing and ask for more time, you've wasted time on the court calendar. The judge could have been hearing someone else's case that day, but instead you have taken time by showing up and then asking for a continuance. And that's disrespectful to the court and the process. When you realize you need more time, ask right away by writing a letter to the court and filing it.
Now that there are judicial metrics that they've got to hit, meaning they've got to close so many cases and things like that, how do you believe that will affect requesting continuances?
As a former immigration judge, I didn't care at all about metrics. For example, I think one of the metrics is that a judge should complete 95% of their individual hearings on the date they were originally scheduled, which means the judge wants to come to court for your final hearing, do your final hearing, and finish it. So when you come in and ask for more time on the date of your final hearing, that cuts against the judge's 95% metric. That 5% accounts for the ones where the judge says, oh, there's good cause, I'll give you more time. As a judge, I'm speaking for myself, I did not care about that. I'm going to do the right thing for the right reason. I'm going to follow the law the best I can. And whether I hit a 95% metric or an 80% metric, I was not concerned. Other judges do care. And so, especially judges that are on probation. And I don't want to necessarily get into the weeds about what that means to everybody, but sometimes when a judge is new to the bench, there different rules apply to them. And so they're being scrutinized more than other people who've been doing it for a long time. They might be more inclined to say no. That's unfortunate. I think due process is what should control and whether someone has met the good cause standard, not a metric that's for administrative purposes. That's my perspective. Don't take a chance, though. That's why you shouldn't wait until the last minute to ask for more time.
Great. And the last question, and thank you, this has been so helpful. The last question is, can a judge order the Department of Homeland Security to give respondent a copy of their case file?
So, no, I don't think a judge should, because that's not the process. As a judge, when I was a military judge and even as an immigration judge, it's always important for a judge to stay in their lane, act only within the scope of their authority. Some judges think because they wear a robe, they've got lots of power. Not necessarily. The power comes from the law. So if it's not in the law, then you don't have the power and you can't make it up. So that's not the process to request a copy of your record. The process is, if you want a copy of your court record, your immigration court record, including recordings of prior hearings, you have to make what's called a FOIA request. FOIA stands for Freedom of Information Act request through the immigration court. And the formal name for the immigration court is the Executive Office for Immigration Review. If you Google, how do I request my immigration court record from the immigration court, it should pop up. I actually tested this yesterday because I wanted to see how easy it was to find. It's very easy to find how to submit the request online. If you want the copy of your immigration file that the Department of Homeland Security has been collecting on you for years that may or may not match with what was filed in immigration court, they also have an online portal to request a copy of your immigration record from them. So you can Google, how do I get my immigration file from the Department of Homeland Security? And that webpage should pop up for you to file it online.
Great. And your answer reminded me of one other question that I get all the time. I have had many clients who say, can the judge now give me their work permit? And what would you say to that question?
Again, outside the scope of my authority. A judge does not have the authority to give work permits. So the judge has to stay in their lane. Now, we don't expect everybody to know that. So if you have a question about what the judge can do or can do for you, then you can ask, and the judge will simply explain that's outside the scope of my authority.
Right. And there's separate offices. The court is under the Department of Justice, right? And USCIS, which gives work permits, is under the Department of Homeland Security. Yeah.
And that's an excellent point too. We are two completely different agencies that are coming at this issue of immigration from different perspectives. We have our own processes.
Well, thank you so much for answering all these questions. I know that everybody's going to find them very helpful. Is there anything you'd like to say before we end?
Only that I enjoyed having this conversation with you, and I look forward to doing this again in the future and maybe taking some questions from the field and answering what folks out there want to know.
Oh, that's right. Let's make the ask right now. If you do have any questions for Shelly, go ahead and submit them in any comments, or you can email them to us. And in future videos, we'll take those. And as you can see, she's the person to ask because she's been there, she's done that, and she really knows it. So, okay.
As a quick disclaimer, though, I'm only ever speaking on behalf of myself, not the former immigration court. I'm just sharing with you my perspective and experience.
Yeah, absolutely. Okay. Thank you.
Thanks.